One of the thorniest problems for any in-house lawyer is that question, how do I terminate this contract? It's never easy. In this interview, Andrew Smith, partner in our litigation team, is going to talk us through how you can terminate a contract and how to avoid those pitfalls. So Andrew, if you want to terminate the contract, how do you go about it?
Well, I suppose the easy answer is do it carefully, because there are a lot of pitfalls in contract termination. But then really the first thing to do is find out what your contractual terms are. And the reason that that is important is it will set out the rules by which you can actually effect that termination. So it rather depends on whether you go down a fault termination or a no fault termination.
So is there a different approach depending on whether it's fault or no fault?
If there is no fault, then you very much have to play by the rules of the game as set out in the contract. If there is fault, i.e. a breach by the other side, then as the wronged party, you've got a little bit more room to manoeuvre.
Let's take the no fault approach. If the contract is silent on termination, what happens then?
Well, if it's silent, you've really got to look at two things. The first is it silent in relation to termination because it's a fixed term contract? So for a given period of time, that's how long the contract lasts. And if that is the case, then I'm afraid unless you breach the contract, you're going to have to wait, because a fixed term contract expires, it can't be terminated, it sort of dies of natural causes. And then if it's not a fixed term contract and there are no termination provisions, then you will have a reasonable period of time to terminate implied into the contract.
So, $1,000,000 question, what is reasonable notice?
Well, maybe $1 million question, but it's also sort of how long is a piece of string question. The reality is it depends on all of the circumstances of the contract. That's how the courts can obtain for themselves the maximum flexibility. I know that's not of much help. So as a rule of thumb, really, I would say that if you've got a long-term contract where there's quite a lot of dependence between the parties, so it's not an easy contract to terminate, I would say that if you're trying to give 3 months notice, you're cruising for a bruising. If you give a year's notice, you're pretty safe, but then you've got a year of a deteriorating relationship. So where I get to in all this is, unless there are very unusual circumstances, between 6 and 9 months gives you the maximum amount of protection, but the minimum amount of time still in the contract you don't want to be in.
So turning now to where there has been a breach, what do you need to consider then?
Well, again, you need to look at the contract, because you may have a right under the contract to terminate for that particular kind of breach. But in addition to that, you should also be looking at whether the breach is sufficiently serious to be a repudiatory breach.
So, repudiatory breach, tell me more.
Well, a repudiatory breach is a breach that goes to the heart of the contract, and as a result of which you can call the whole thing off. You can say that the contract is at an end. And there are 3 basic types of repudiatory breach. One that's based in the past, and 2 in the future. So the past would be where there has been a breach and it is so substantial as to go to the root of the contract. And then the 2 future ones, there's renunciation, which is effectively where you say, I'm not going to be bound by the contract. The classic example of that would be by giving a 3 months notice when you should have given much longer. And then impossibility, which, as the name suggests, is where you've rendered further performance of that contract impossible. So an example of that would be, let's say I was to say to you, yes, let's have a contract for me to provide to you a Ming vase in 2 weeks' time, and then in a week's time I'd go and sell it to somebody else. So it would render the performance of that contract impossible.
So how can I tell whether it's a repudiatory breach or not?
The law is never an easy thing, but it is a question of feel. How serious is the breach in the circumstances of that particular contract? Again, I recognise that's not particularly helpful. So there are some hints that you can glean from the contract. So for instance, if a term is expressed to be a condition in the contract, then that is effectively shorthand for if you breach that term, it will be a repudiatory breach. And the corollary of that is if, in fact, it's a warranty in the contract, a breach of that will only entitle you to damages and you won't be able to bring the contract to an end. Another classic would be time of the essence. If you have time of the essence in the contract, that is effectively telling the other side and the courts and the whole world that breach of that particular time-related term of the contract will bring a termination. If you're a minute late, you're late, you can terminate.
In a lot of the contracts that I draft, it refers to material breach. Is that the same as a repudiatory breach?
No, it's not quite the same. Repudiatory breach is the one that goes to the heart of the contract. It doesn't actually have to say this is a repudiatory breach. A material breach is written into the contract and it's trying to cover off breaches which are sufficiently substantial, i.e. not technical breaches or very small breaches, so that it allows you the right to terminate under the contract. It's a similar concept, but the courts have been very clear that they are different things.
If the contract already includes a termination right, does that prevent you from taking the repudiation route?
No, it doesn't. The courts have determined that as well. You have both rights. The difficulty is you've got to really pick a lane, choose which one you go down, because if you choose one, then it can prejudice your right to go down the other. There are some little tricks of the trade where you can try and maintain both rights, which can be advantageous, but really they're so complicated I can't really explain them now.
So if I have a choice, what factors should I take into account in making that decision?
There are quite a number of quite important choices to be made in relation to your right to terminate under the contract or to accept a repudiatory breach. And if you have that choice, I'd say the main one is your right to damages, because if you terminate under a contract, you're entitled to damages up to the date of the termination. If you accept a repudiatory breach, which could be on the same facts, then you're entitled to what are called loss of bargain damages, which can cover future loss. So to give you an example, if you had an HP contract and you terminated as the wronged party for breach under the contract, you'd be entitled to all of the missed payments up to the date you terminate. If you accept the repudiatory breach, if you're entitled to, then you would be entitled not only to those missed payments, but all your future payments under that HP contract.
I can see there's a lot of decisions. What happens if I get it wrong?
That's a bit of a problem. It's a bit like the scene from Reservoir Dogs, where there's one person pointing a gun at your head and you've got a gun against theirs. If you get it wrong, then you yourself are committing a repudiatory breach. If you terminate wrongly, then that is evidencing an intention no longer to be bound by the contract. It is a renunciation, one of those three types of repudiatory breach I mentioned earlier. And that will mean that the other side has the ability to call the whole thing off and claim loss of bargain damages. So it's something you need to think about long and hard and make the right decisions, because if you get it wrong, it'll go horribly wrong for you.
Given that risk, is there any way I can minimise it?
It's really a matter of balancing your legal protection in trying to stop being sued for getting it wrong and for damages, and trying to maintain your commercial drivers, because actually you wanted to terminate the contract. So the longer notice that you give to the other side, the safer you're going to be in litigation terms, but commercially that may be unattractive. When you decide to terminate for breach, what you've got to do is think long and hard about what rights you have and how best to go about them.
Andrew, thank you for leading us through what is a really complex area and giving us some really great practical tips.
Thank you.